Hi, this is Nissan reporting for case number 113, Solomon Boysaw and Alfredo Yulo Jr. versus Interphil Promotions Incorporated, Lope Sarreal Sr. and Manuel Nieto, docketed on GR number L-22590, decided on March 20, 1987. Facts of the case. On May 1, 1961, Solomon Boysaw and his then manager, Willie Ketchum, signed with Interphil Promotions Incorporated, represented by Lope Sarreal Sr., a contract to engage Gabriel Elorde in a boxing contest for the Junior Lightweight Championship of the World. It will be held at the Rizal Memorial Stadium in Manila on September 30, 1961, or not later than 30 days thereafter should a postponement be mutually agreed upon, and that Boysaw would not, prior to the date of the boxing contest, engage in any other such contest without the written consent of Interphil Promotions Incorporated. On June 19, 1961, Boysaw fought and defeated Louis Avila in a 10-round non-title bout held in Las Vegas, Nevada. On July 2, 1961, Ketchum assigned to J. Amado Araneta the managerial rights over Solomon Boysaw, who then assigned it to Alfredo J. Yulo Jr. The latter wrote to Sarreal informing him of his acquisition of the managerial rights over Boysaw and indicating his and Boysaw's readiness to comply with the boxing contract on May 1, 1961. Because of these changes, the fight was rescheduled on November 4, 1961. Yulo Jr. refused to accept the change in the fight. As a result of the foregoing occurrences, Boysaw and Yulo Jr. sued Interphil, Sarreal Sr. and Manuel Nieto Jr. for the damages alleged occasioned by the refusal of Interphil and Sarreal to honor their commitments under the boxing contract of May 1, 1961. Issue: whether or not there was a violation of the fight contract of May 1, 1961, and if there was, who was guilty of such violation. The court ruled that the evidence established that the contract was violated by appellant Boysaw himself when, without the approval or consent of Interphil, he fought Louis Avila on June 19, 1961. While the contract imposed no penalty for such violation, this does not grant any of the parties the unbridled liberty to breach it with impunity. Our law on contracts recognizes the principle that actionable injury inheres in every contractual breach. Thus, those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who in any manner contravene the terms thereof, are liable for damages.